Hello and good evening. I'm Melisa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. Last year, Parliament passed some amendments to the Evidence of Child Witness Act to provide more rights and protections to children who are testifying in court. Now, the court process can be a daunting and intimidating one for adults, but even more so for children. Now, the stress a child victim endures in trying to seek justice can sometimes result in many deciding to give up before the end of the process. So in a bid to ease the journey to seek justice for child victims, further amendments to the Evidence of Child Witness Act are now being proposed to make the courtroom experience better for children so they will be able to give their best evidence. Joining us on the show now to discuss this further is Sharmila, Sekaran, Chairperson of Voice of the Children. Thank you so much, Sharmila, for joining me on the show today. I want to talk a little bit about the kind of standard criminal trial procedure, which has been designed for adults. So talk to us a little bit about how these procedures kind of fail to take into account children who are testifying in court, most of whom are victims themselves. How do they face this adversarial defense lawyer, sit in this very hostile and foreign setting? How do they fail to take into account the experiences of a child?
Melissa, first off, thank you for having me on this. But really, even adults struggle with, the entire system, the court system, and the adversarial process. We have to recognize that adversarial process is not something which is normal in any of our lives. It may be normal in the lives of lawyers who go to court, litigation lawyers, but when we speak even among ourselves, it's not so kind of yes and no and structured, right? So even adults struggle with the whole formality, solemnity, adversarial process. How much more for a child? And we have to recognize when we talk about a child is someone who's below the age of 18. There's a huge difference between a 4-year-old, a 6-year-old, and a 15 or 16-year-old, both in terms of the cognitive and language development, right? Mm-hmm. So children really are at a huge disadvantage because of this. Like you mentioned, it's a very foreign and unnatural environment for them to be in. Suddenly, they see people sitting up on a desk right in front of them, up high. They often have to sit in a witness stand. It's not something which is very much within the purview and life experience of a child, especially the younger children. And most would not even have had an opportunity to watch courtroom dramas on TV to get some kind of idea about it. So really, they're at a huge disadvantage. And then when we bring into account in fact, like a contest between this young, vulnerable child, even a teenager, and an experienced defense counsel, schooled in law, schooled in the understanding of a very foreign system, foreign to everyone else. It's inherently unequal. It's not a level playing field already. So when we bring into account our adversarial system, even the cross-examination questions are designed to confuse. And very often they're intimidating. They are designed to manipulate and confuse the witness and thereby to elicit the truth from the witness. But for children who are still developing cognitively, this is all the more confusing. And what we find is very often they give conflicting or wrong evidence, wrong testimony, conflicting testimony, and then everyone says, oh, look, they're unreliable, they're untruthful. It's not that they're being untruthful, it's just they didn't understand what you're asking them.
Right. So there are lawyers who say that this is meant to expose any inconsistencies in testimony. This is for the rights of their client to have a fair trial. That how do you respond to lawyers who say this is necessary in the pursuit of justice for their client?
Yeah, bullying a child is not necessary for justice. No, what we are asking for really and hoping will happen is that the playing field will be leveled for the child. So at the moment, as rightly mentioned, the system is very adult oriented. It is not child friendly. And so what we're saying is create a more child friendly environment so that the child can give his or her best evidence. This does not mean that defense counsel cannot ask questions, cannot challenge the child's version of events. That does not mean, what we're saying does not prohibit that. But what we're saying is, for example, if you're talking about a younger, someone years old, a 6-year-old, a much younger child, ask simple questions that they can understand, and they will tell you their version of events. Now, you can say their version of events is not right and put to them a different version of events. I don't think your recollection is right. Maybe, or is this not the case? But what we're saying is, depending on the age of the child and the abilities of the child, each to be assessed and tested for each child on a case-by-case basis, you are giving the child a good environment to be able to give his or her evidence in the best way. So what we're doing is putting the best interests of the child at heart, but in no way diminishing or eroding the rights of the accused to fair trial.
Okay. How do we think about how children or child witnesses might experience either additional trauma or secondary victimization from the court process? I'm wondering how the legal system can be further adapted to ensure that child witnesses are not re-traumatized by the entire trial process.
So, this is why we need to know and understand the specific child before us for each case. And really what we're hoping is that the prosecution will work with a team to be able to understand the needs of each individual child who comes, in particular if the child is a victim. And when we say victim, I'm talking about primary victim, we also have to remember that sometimes children come to court as secondary victims, i.e. witnesses of an offending act, and that is traumatic in itself for a child. But when we talk about a child witness, what we really need to ensure is that the child does not have to tell and retell, repeat a bad experience that they've had. And, if I can give the example of a child who has been sexually violated, that is already a traumatic experience. Even coming to terms of the fact that what has happened to them is very, very wrong and something they were not able to and did not consent to. To now have to tell that story repeatedly during examination in chief, when the prosecution asks them, when the defense counsel questions them, and when someone is suggesting to them that everything they say is a lie, is an untruth, is a fabrication, right? And that is how cross-examination does happen. You are lying, it's fabrication. I put it to you that, this is the alternative. And, it's very, very intense. It's rapid fire questioning. Adults find it traumatizing. Children just freeze up. They just, it's deer in the headlight kind of thing for them. And the result is they clam up and they end up withdrawing from the entire process, which is not justice. And for an accused to get away just on this courtroom drama, if I can put it like that, or on technicalities, cannot be seen to be justice. So what we're saying is, let us have fair justice. The accused must have their day in court, and they must be allowed to question a child, any witness, even if it's a child witness. They must be allowed to question the child and put forward the defense case to the child, that the child's version may not be true, but it's how you do it. That is what we're talking about, the style and format. So shorter questions, for example, not long, convoluted questions that at the end of the day, even adults are saying, I'm sorry, can you please repeat that? Right? So, it's so much worse for children, and they may not have that knowledge and ability to say, I don't understand, can you repeat the question? Right? So it's about taking the child's ability into account, but not, like I said, not eroding the rights.
So, Sharmila, how does that translate into strengthening the current legislation, into improving the current structures and practices of the criminal trial process?
So one of the things that is in play currently, as the law stands, is that children below certain ages, or depending on their ability, are allowed to give unsworn evidence. So, when all of us go to court, before we give evidence, any of us, if we are going to be witnesses, before we give evidence, we have to take an oath, right? And we have to swear to tell the truth. Now, the situation is such for children is that doesn't really mean anything to them. Can you swear to tell the truth, the whole truth, and nothing but the truth? That doesn't mean anything to them for some children, when they're, especially the younger ones. If you just tell them, can you promise to tell the truth? Can you promise not to lie? And they say, yes, I promise I'll tell the truth. That has the same effect for a child as an adult kind of swearing and saying, I tell the truth, I promise to tell the truth. It has the same effect, the same level of gravitas. The child is now going to be afraid to lie because, one, not because the children lie naturally, but because you have now caused them to make a promise, and they don't want to break a promise. They know that it's wrong to break a promise. So because they've promised you to tell the truth, they will now tell the truth. Okay? That does not mean, again, that, like with adult evidence, the court, the judge, the magistrate will weigh the evidence from the child and any other evidence that's before the court, other witnesses, even at the end of the trial, the defense and the defense witnesses. They will weigh and say, okay, which version of events do I prefer and for what reason? We see that in the trials happening with adults even now, where they say, I prefer this person's testimony. I did not find this other witness reliable. And that stands for a child. And we're not changing anything that is already in existence for the law. What we are saying is, one, that children, we're proposing that a child from the age of 12 should be able to give sworn evidence, i.e., I promise, swear that I promise to tell the truth. But if a child is below the age of 12, that child is still able to give evidence, and it's still accepted and going to be treated like the evidence of the 12, 13, 14-year-old and an adult. The young child having already promised to tell the truth, right? And we give it the same weight and the same treatment as we would adults' evidence. At the moment, if a child gives unsworn evidence, that means they've not sworn to tell the truth, then what happens is the court asks for corroborative evidence or other evidence to support what the child is saying. The reality is, when child abuse happens, especially sexual abuse, it's not happening in broad daylight. It's not happening in the view of other people. It happens under secrecy, under the cloak of darkness. So what other corroborative evidence is there, unless there's penetration? If there's penetration, if there's semen, fine, yes. But if penetration was using a different object, if there was no penetration, if it's just fondling and things like that, there is no other evidence that we can use. And all of a sudden, that child doesn't get justice. So this cannot be right. And we cannot, as a society, we cannot allow this. So we need to say that, yes, even if a child is unable to swear to tell the truth, the child can make a promise, and evidence shows, research shows that promise has great value. The child treats it very seriously, and then you just test the evidence like you do every other So those are some of the amendments that we're looking for.
Right. Sharmila, thank you for sharing those with us. I appreciate your time. Sharmila Sekaran, Chairperson of Voice of the Children. We're going to take a quick break and we're going to come back and talk more about the amendments to the Evidence of Child Witness Act. Stay tuned to consider this. Hi, welcome back to Consider This. I'm Melisa Idris. Let's continue our discussion about strengthening the Evidence of Child Witness Act through new proposed amendments. Joining us now is Karen Lai. She's the Program Director at the Women's Centre for Change, WCC, in Penang. Karen, thank you for being on the show with me today. If I understand correctly, currently testimony by child witnesses, they're not treated the same way or with the same level of reliability as adult witnesses. So maybe you can start there. Elaborate for us what this means. How do the courts view the competence and the credibility of child witnesses to testify?
Hi, Melisa. Thank you for having me back on the show. It's great to be back. On this point, I think we all know that historically, society has considered children to be less reliable than adults as a whole, right? So people think mainly that children are prone to making up stories, they can't distinguish fantasy from reality and so on. And unfortunately, this societal assumption has found its way into our law. Now, compared to adults, child witnesses are presumed to be both less competent and less credible when they give evidence. Now, court processes we know are designed specifically for adults. So competency refers to one's ability to understand questions and give rational answers. Yet, if these questions are posed in a way that is child-friendly, in a manner that is appropriate to the child's age and level of understanding, then we can safely assume that children will be competent to testify. So there's no issue there. As for the credibility of children's testimonies, if there's doubt that they tend to lie and so on, the research shows otherwise, yeah? There's actually no correlation between one's age and one's honesty. Just because you're an adult doesn't make you less prone to lying. Now, realistically, children are no more prone to lying than adults, as I said. And in fact, if anything, they may be even more cautious about lying in court compared to adults. From what we know, studies show that children as young as 3 or 4 are able to give reliable accounts of things that have happened to them, especially things that are meaningful and traumatic. For instance, they're not easily manipulated into fabricating abuse, and they're not good at making up lies, and particularly sustaining those lies consistently over time. If anything, ironically, you could say that it takes adult skills to do that. I don't know if you've ever talked to a child and tried to tell the child to keep something up, or lie, and they adamantly stick to the truth. I think, so in other words, I think the law isn't founded on realistic situations or psychological states of children, in that sense. So the bottom line is we need to make court processes more child-friendly, right, with age-appropriate questioning techniques and so on, rather than automatically assume that children aren't competent or aren't credible as witnesses.
Okay. All right. So how do we do that? How do we strengthen the Evidence of Child Witness Act? Talk to me more about the changes that are being proposed.
So I'd like to highlight 3 key areas of changes that are being proposed that I believe will help to bridge these gaps, right? Competence, corroboration, and also pre-trial case management. Now, when it comes to competence, the changes that are being proposed are that there is now a presumption that every child is competent to testify in court. So there's no more issue on that. There is the setting of 12 years old as the standard age where children are presumed competent to testify under oath. And if the child doesn't meet this requirement, then the child can give unsworn evidence, that is evidence that's not under oath, and the court must require the child to make a promise to tell the truth. Now, this type of promise is actually the age-appropriate equivalent of taking an oath because it's something the child can understand, right? But importantly, whether the child gives sworn or unsworn evidence, the new changes removes the distinction between the weight of the evidence or the the effect, the credibility. In other words, this is an important recognition that there's no link between whether the child swears an oath, understands it or not, and whether the child tells the truth, right? So it recognizes that basic competence of children to give evidence. Of course, as a safeguard, the court can conduct an inquiry into the competency of the child witness, right? Whether it's of its own motion or if anyone applies, let's say the defense counsel has concerns with the child's competence. Yes, of course, there's always that safeguard in place where they can apply for an inquiry into that issue, right? And during the course of this inquiry, the court can call other witnesses to actually assess the child's competence. So that's helpful. So that's the first area of change that is significant. The second area, which is also very significant, is courts can now convict accused persons based solely on a child's testimony, whether sworn or unsworn, right? This is known as uncorroborated evidence. Corroboration means having additional evidence to support or back up that child's evidence, right? And previously, if the child did not give sworn evidence, if the evidence was unsworn, then that evidence on its own, without further corroboration, cannot be used to convict an accused person. Now that is removed. Now, the Sexual Offences Against Children Act in 2017 has already removed that requirement in relation to sexual offences against children. Now, with the changes to the Evidence of Child Witness Act, this will be applied to all children, right? We're extending the protections to all children. So it's a recognition of children's competence. Yeah, it's a recognition of their status to give evidence. And last but not least is pre-trial case management. Now, pre-trial case management procedures are already provided for under the law, but I would say that the current changes in the Evidence of Child Witness Act further refines this management process by proactively using the pre-trial case management process for judges to give mandatory directions tailored specifically to child witnesses. And this is really helpful. This includes things like age-appropriate questioning, right? What type of question is suitable for the children? Duration of the questioning. For instance, how long is it going to take you to question this child, right? In examination, achieve a cross-examination, because anyone who's been a witness will know that it's not easy to keep going, right? For even an hour non-stop. So do they need a break? Do they need special equipment such as video live link or special tools, right? So all this is done efficiently and systematically during pre-trial case management. Interestingly, during case management as well, I would say importantly, courts can also call for expert evidence to help determine measures to assist the child witness. For example, the child's age, any special needs they have, any specific wishes they may have, and so on. So this is important to ensure that the child witness is given the support they need in order to testify effectively. So in summary, with all these amendments, the court will no longer need to treat children's evidence with extra suspicion just because they're kids.
Karen, can I come back to the second change that you mentioned, the conviction based on a child's testimony? So help me think that through. What are the potential benefits and the risks of allowing courts to convict an accused person based solely on the testimony of a child?
Well, I think the most critical benefit is improved access to children, particularly child victims of crimes, right? And crimes which often occur in secret. Now, the evidence of the child will now be sufficient for corroboration without requiring, will be sufficient for conviction, pardon me, without requiring additional corroboration. And this is important because in such situations, you often can't find eyewitnesses. It's very, very difficult to get, this additional support or backup evidence as such. Now, I want to stress that this does not mean automatically convicting the accused. That's very important to understand, right? People get the wrong idea and, oh, no, going to get convicted for that. No. Rather, what it means is the courts will be empowered to assess that child's evidence on a case-by-case basis, same way as an adult, based on merits, right? And now the same concept, as I mentioned earlier, is already applied in the Sexual Offences Against Children Act, because it's we all know, sexual offences tend to happen in private. It's very difficult to get corroborated evidence and so forth. And this removal of the corroboration requirement has proven to be successful. And now we are extending this protection beyond child sexual offence cases. In terms of risk, I think the converse side of it would be that people still think that children are going to be given false evidence, right? Accuse people falsely, give inaccurate testimony, whether intentionally or unintentionally, right? And then and that the accused is going to be wrongfully convicted. There is a perception here that the rights of the accused will be eroded in that sense, yeah, or compromised. But in reality, I would say that this risk is unfounded because various safeguards still, they remain in place to protect the accused. First of all, the burden of proof beyond reasonable doubt is still there. The prosecution still has to prove the accused's guilt beyond reasonable doubt, and this is a very strict and very high standard. It's not easy, right, to simply secure a conviction. Secondly, the courts, despite the removal of the corroboration requirement in the Sexual Offences Against Children Act, the courts remain very cautious. The child's evidence has to be clear, it has to be detailed and consistent. In other words, it has to be unusually convincing to stand on its own without corroboration, right? So all in, it provides additional access to justice.
Okay, well, and that's so important, Karen. So we know that, you know, sometimes the stress that a child victim goes through in trying to seek for justice, sometimes they decide to give up before seeing the end of that process. So we want to make this experience, courtroom experience, as easy and better for children so they have access to justice. When, in the couple of minutes that we have left, can you share with us what are the barriers that children face when they try to seek justice under this existing legal framework?
Absolutely. There are numerous challenges faced by children in accessing the justice system. Yeah. So when it comes to child victims of a crime, for instance, child sexual abuse, depending on their age and maturity level, there are many factors involved. Whether the child can or even will report the incident, right? A child could be confused. Yeah, they may not realize that they're being abused because they're being groomed. They have a relationship of trust with their perpetrator. They're threatened by their family. They feel shame, guilt, fear, and so on. So it's so difficult to even get the child to report the incident in the first place and even enter the justice system. So that's the first big barrier, right? And secondly, even when they do disclose the offense and they enter the system and report the crime, there's a general lack of sensitivity to their needs. And this can result in what's known as secondary victimization. This is the harm that's caused by those who respond to the victim within the justice system, right? Such as insensitive questioning or comments by the police, hospitals, social welfare, or even prosecutors, defense counsel, and courts. So they go through this secondary level of victimization, which makes it very hard, right? And speaking more broadly, because the changes in the Evidence of Child Witness Act affects children, all children, yeah, not just children in criminal proceedings. Broadly speaking, many children lack access to adequate legal representation or support, especially in cases involving, you know, abuse, custody disputes, immigration issues, and so on. Because our entire legal system is geared towards the needs of adults, right? So children may not be aware of their rights. Very likely they won't be aware of their rights, let alone how to assert or realize those rights, especially if they're being exploited and they're particularly vulnerable. And on the whole, there's an overall lack of specialized support services for children involved in legal proceedings, whether it's counseling or support on the law or even support in court. So those are just some barriers that children face in the system.
Karen, thank you for highlighting them to us on the show tonight. Appreciate your time. That was Karen Lai, Program Director at WCC Penang, wrapping up this episode of Consider This. I'm Melisa Idris, signing off for the evening. Thank you so much for watching, and good night.